it's time for us to talk about use of force. You need to understand when you can use force, when you can't, what reasonable force is, and what isn't. Your FTO may have already covered some of this with you. Whether he has or he hasn't, we'll discuss it, and your FTO will be available for you to talk about anything you need to or to ask any questions if you like. We'll try to keep this brief and short. Use of force cases can be very in depth. We're just going to kind of give you an top level of some of the things you need to know, but I do definitely encourage you to read some of the case laws that we talk about, to look at some of our use of force policies, possibly watch some videos associated with some case laws, and just ask a lot of questions. It can be a very in-depth conversation to have. So first, we need to identify what force is, or what is a use of force. For law enforcement officers, this is just any action that you take against another person to compel compliance. Or you can also look at a use of force from a suspect's perspective. This is force used against any other person that could cause bodily injury. So that's kind of two easy ways to look at it. We've got some statutes, case laws, and policy that govern our use of force. The first of these is Graham v. Connor. This is a 1989 case. You should remember this in mandate, and if your F2 has already spoken with you about this, he should have covered this with you as well. Just as a refresher, this is where the officer was monitoring a convenience store. He noticed the car come in to the convenience store. Somebody got out, ran inside, quickly exited the store, didn't appear to have bought anything, returned to his car, and the car sped off. The officer thought that possibly an armed robbery had occurred, so he pulled the vehicle over, and the subject got out, was not following commands, not listening to anything that the officer said. The officers ended up using some control tactics on this person. He got a few injuries, and he eventually came back and sued that officer and the agency involved. Now, if you remember this case, this was a diabetic person having a diabetic episode. So if you look at it in his eyes and the eyes of the family, his family and friends, all they're going to be seeing and thinking about is, my brother or my father or my son or whoever that person was to them. They were having a problem with their sugar, and the officer stopped him and ended up beating him and injuring him and some other things. Well, the court said here is that hold on, let's back off just a second here. To begin with, the officer could not have known that the person was having a diabetic episode. He knew he just needed that there was possibly an armed robbery. He needed to investigate it, and the person that he was attempting to speak to and interview was basically resisting arrest at the time. So, with that being said, the courts eventually ruled that this is okay, but they say that any use of force case must be judged by another reasonable officer on scene. So, not saying that it has to be another officer that was there, just any reasonable officer who could place themselves in the officer's shoes and say, yes, I would have done this, or no, I would not have done this. They also finally came up with a 3-pronged test to determine if force is reasonable. Now, this test first wants to know, as the first prong, what is the severity of the crime at issue? Obviously, there's going to be a difference between an armed robbery and a shoplifting case. Second, they want to know if the person is an immediate threat. So, if an unarmed person with no weapons is standing 100 yards away from you, he is not much of a threat. However, if a person at that same distance has, for example, an AR-15 or some other kind of rifle or pistol or any firearm, even if they're not pointing it at you, they are a threat. They can pose an immediate threat. Okay? Moving on from there, the courts want to know the third prong of the test: is that subject actively resisting or attempting to escape? So now, are they using whatever method that's causing them to be threatening or item? Are they using it? So are they pointing that weapon at you? All right. So what's the crime that you're investigating? Does the person pose a threat, and are they actively working as that threat? So you need to be able to answer those questions. As far as a reasonable use of force, a definition for it can just be, any amount of force that is necessary to accomplish a lawful objective. So you must be performing a lawful objective, and the force must be necessary based on your situation and the totality of the circumstances. And again, that's judged by another peace officer that can place himself in your shoes or the shoes of the person using force. So, just moving on along from there, we get Tennessee v. Garner. Very simple. I'll keep this one real short. This was a guy, he was working, the officer come to a home, someone run out the back door on a burglary, and he jumped over the fence, the officer shot him in the back. So during this time and the times before, there was many officers around the country thought that you could shoot a fleeing felon just because they were fleeing as a felon. So felonies, bad, those are generally bad crimes. So they thought, well, if he's a felon, we probably need to stop that person. And the courts finally said, no, we're not just going to do that. They need to be a threat. So Tennessee v. Garner just said we can't shoot all fleeing felons just for the sake of fleeing. They need to be either an immediate threat or they need to be a threat should they escape. So had they have injured or killed a family inside of the home during the burglary, you may articulate that, well, if he were to escape, he could have done this again to someone else. But simply for fleeing a nonviolent crime without any weapons and not posing any threat, the courts say, no, we're not allowed to do that. Just to briefly cover another law, Scott v. Harris, this deals with chases. I recommend you looking it up on your own. This is a case that's kind of close to home. There's another one known as Mixon v. Warner Robins. You can look up either of those. But Scott v. Harris just deals with chases, and it says you're not liable for any injuries or damages that occurs due to terminating the chase. And that means if you cut your lights and sirens off and turn around and go the other way during a chase, but the suspect continues on and they kill someone or damage property, they say no, the officer's not liable for that. Now, to move on from there, we have our case law that covers the use of force. This is 17-4-20, subsections B, C, D, and E. So I'm just going to recommend that you read over that statute. I won't spell it all out for you for time's sake. I will say in the statute it does specifically say that warnings are required before you use force. However, they're only when feasible. So the state does require you to give a warning, but there are exceptions when you don't have to give a warning. So if someone is standing a few feet from you and raises a pistol at you, the state is not going to expect you to tell them to stop before you use force against them to stop them. It's only when it's feasible to do so. So just remember that if you have time to safely tell somebody or give somebody a warning that you're going to use force against them, you need to do that. You also should review our policy. Our policy dictates that lethal force may only be used when there is an immediate threat of serious injury or bodily harm or death. And I always try to use the least amount of force necessary to accomplish the objective. Just keep that in mind when we're talking about our use of force cases. I do want to throw out there, and we'll talk about this more later on, our sheriff's office here does provide classes at Dublin Jiu-Jitsu when it comes to using force. If you have more control, if you're more confident in yourself, more confident in your abilities, that can typically lead to using less force because you know that you can go hands-on with someone rather than having to use a taser or some other type of weapon. All right, so ending there, we'll stop with this. If you have any questions, reach out to your FTO. Feel free to come reach out to me. I do want to point out the use of force paradigm. It's a little model inside of the FTO program. This sort of just gives a general guideline on when you can use certain items such as chemical agents, pepper spray, such as pepper spray or taser or firearm. So you can kind of look through that if you like. It's just a decent illustration. There may be some questions that arise out of it. I'll be happy to answer them for you. But overall, the most important thing, if you have any questions, research those case laws, Graham v. Connor, Tennessee v. Garner, research the statutes, 17-420, and read our policy. So we're going to end it here until we get into the next section.